Hello dear students, my name is Dr. Deepa Dubey. I am Associate Professor at the Rajiv Gandhi School of Intellectual Property Law, IIT Kharagpur. Today, the topic of our discussion is cyber pornography. Before we proceed, let us know the learning objectives. 1. To make the students understand the nature and extent of the problem of cyber pornography. 2. To make the learners understand the threats of child pornography and its impact on society. Third, to make the learners acquainted with the law on the subject and the offences created thereunder. So, this problem of pornography is presently one of the most serious problems arising from the use of the internet in present times. It has created a fear and moral panic among the government, law enforcement and civil society. Pornography has the trend of affecting the lives of hundreds and thousands of people through its addictive content and seriously preys on the health, safety and well-being of the individual, the family and the society at large. Where the matter relates to child pornography, the concern is even greater. According to studies, sex industry, including pornography, is one of the largest and most profitable industries in the world. Pornography industry is stated to be bigger than the top technology companies combined together: Microsoft, Google, Amazon, eBay, Yahoo, Apple, Netflix and Earthlink. Statistics indicate that every second about $3,000 are being spent on pornography around the world. Every second, 28,000 internet viewers are viewing pornography. Every second, 372 internet users are typing adult search terms in search engines, and every 39 minutes a new pornographic video is being created alone in the United States. A survey in India also revealed a similar picture. Close to 47% Indians log on to porn sites from their desktop, while another 50% use their mobile phones to view pornography. Indians make up for the fifth highest number of daily visitors to porn sites. The pornography industry is thus on a constant rise, with people, young and old, glued onto it, while thousands others are being exploited to feed onto the lust and obsession. What is pornography? The word pornography is derived from the Greek word porne, meaning prostitute, and graphe, meaning to write. Pornography thus was originally defined as any work of art or literature depicting the life of prostitutes. In present times, it denotes the depiction of sexual behavior in books, pictures, motion pictures and other media that is intended to arouse sexual excitement in the audience. It includes graphic, sexually explicit contents which tend to demean and dehumanize human beings, mostly women and children, into sexual beings. Pornography as a visual representation of sexuality distorts an individual's concept of sexual relations by objectifying them. Recent research suggests that pornography consumption, especially consumption of a more hardcore or violent sort, has negative impact on individual and society. Addiction or constant use of pornography can be psychologically addictive and negatively affect the quality and interpersonal relationships, sexual health and performance, and social expectations about sexual behavior. Widespread pornographic consumption appears to pose a serious challenge to public health and to personal and familial well-being. Types of pornography. There is generally three types of cyber pornography: hardcore, softcore, and the third, child pornography. Hardcore pornography refers to still photography and or video footage of explicit sexual acts which include vaginal or anal penetration, cunnilingus, fellatio and ejaculation and or extreme fetish acts. The term was coined in the second half of the 20th century to distinguish it from softcore pornography. It usually takes the form of photographs often displayed in magazines or in internet or films. Softcore pornography is a form of filmic or photographic pornography or erotica that is less sexually explicit. It is intended to tickle and arouse men and women. This pornography depicts nude and semi-nude performers engaging in casual social nudity or non-graphic representations of sexual intercourse or masturbation. In most cases, the sexual acts depicted in this pornography are entirely simulated and the actors and actresses do not actually indulge in the act. Child pornography involves photographs and films of children that are sexually explicit. Sexually explicit conduct may include sexual intercourse, bestiality, masturbation and exhibition of the genitals, etc. It can also be defined as the visual depiction of minor children under the age of 18 in various sexual acts. Child pornography is banned all over the world. What is the extent and impact of child pornography? It is one of the most despicable forms of child exploitation or crimes against children. It is different from other crimes because as it happens, it involves a crime being committed. The children in the pictures are subjected to horrific sexual acts including beating, burning and other forms of sexual depravities. Every pornographic picture of a child involves a suffering. Commercial child pornography industry is a multi-million-dollar industry infiltrated and operated by elements of organized crime and by a nationwide network of individuals openly advertising their desire to exploit children. It is estimated that tens of thousands of children under the age of 18 are filmed and photographed while engaging in sexually explicit acts. The effects of child pornography on the victims are gruesome. Because children are sexually abused, in the creation of the pornographic images, they incur physical injuries such as genital bruising, cuts, lacerations and sexually transmitted diseases. The children may suffer psychological injuries including depression, anger, withdrawal, low self-esteem and feelings of worthlessness. These feelings may be expressed in flashbacks, nightmares and other indications of post-traumatic stress syndrome. They often engage in self-destructive behavior including substance abuse, prostitution, depression and suicide. When the pornographic images are viewed by others, the children depicted are victimized once again. The mere knowledge that the images exist and are being circulated causes shame, humiliation and powerlessness. This victimization lasts forever since the pictures can resurface anytime and this circulation has grown exponentially because of the internet. Today, the internet enables the speedy, efficient and anonymous distribution of child pornography on a global scale. Anyone with a modicum of technical expertise can access child pornography through either the World Wide Web or news groups. Furthermore, much of this internet-related pornography is free. Child pornography is one of the few commodities that can be transferred over the internet in the sense that the information required to construct a picture can be rapidly and easily distributed over an existing widely available network. Once the picture has been copied and distributed, its further distribution is wholly out of control. it can always be further copied and the distribution continues. Thus, child pornography violates the victim's rights of privacy and human dignity. The possessor has real victims and actual harm is committed by his conduct. Components of cyber pornography. It can be divided into three stages: production, distribution and downloading of images. In some cases, the same people are involved in each stage. However, some producers and or distributors of pornography are motivated solely by financial gain and are not themselves involved in the act of pornography. Production refers to the pornographic material being produced. It is generally done in countries where it is legalized like US, Brazil, UK, Germany. The production is done through three ways. First and most common way of producing pornographic material is the cinematographic production. This kind of production is in practice since 100 years. The second way of production is by the mobile phones with cameras inbuilt in it, which has accelerated the production of pornographic material in recent times. This production has started recently due to the technological advancements which have taken place. The third way of production is by computer generated graphics. Since 2000, it is person including a child can access pornographic material from any computer or a mobile phone with an internet connection and actively seek out pornographic websites or subscribe to a group dedicated to pornography. The above three problems make pornographic material very much accessible and available in great amount to the person who is willing to access and also to the person who accidentally accesses through spam mails, etc. What are the challenges of cyber pornography? The opening of the internet has opened up new vistas of learning, information, products and services to the people without any geographical barriers. However, the same development has also opened new possibilities for criminals and new patterns of criminal activities, including the internet as the medium. These criminal activities are in constant evolution and the law and enforcement has obvious difficulties in keeping pace. The intrinsic cross-border character of this new type of crime has also created a need for improved cross-border law enforcement. The internet has aggravated the problem of pornography by increasing the amount of material available, the efficiency of its distribution and the ease of its accessibility by allowing access to enormous pornographic images from around the world, due to which it has proved extremely difficult to detect and prevent the distribution of pornography. Moreover, there is a consistent lack of consensus on how to deal with the issue. While some argue that a global internet regulation system is necessary, others argue that strategies such as the development of filtering technologies, etc., may be more appropriate. As stated by the Delhi High Court in the Avinash Bajaj case, the regulation of pornography on the internet has posed a serious challenge to government and legislatures, primarily on account of the nature of medium. The easy availability, even to children, of pornographic material in digital form, including video clips, its rapid transmission across the World Wide Web, and the absence of effective filters to screen out objectionable material from being accessed are factors that compound the challenge. It is said that controlling pornography on the internet is problematic because we may not know from whom and from where the material originates, how many people are receiving the information, or if the material is crossing international boundaries. Wortley and Smallbone has identified the major challenges to including the following. First, the structure of the internet makes control of pornography very difficult. The internet is a decentralized system with no single controlling agency or storage facility. Because it is a network of networks, even if one pathway is blocked, many alternative pathways can be taken to reach the same destination. Similarly, if one website or news group is closed down, there are many others that can instantaneously take the place. The decentralized nature of the internet and resultant difficulties in restricting the distribution of pornography is exemplified by peer-to-peer network involving direct connections amongst computers without the need for a central server. It has been argued that the internet is the ultimate democratic entity and is essentially ungovernable. Second is the uncertainties of jurisdiction. The internet is an international communication tool that crosses jurisdictional boundaries. Not only is cooperation amongst law enforcement agencies necessary to track offenders across jurisdictions, it is required to coordinate resources and avoid duplication of efforts. Parallel operations run from different jurisdictions may unknowingly target the same organization or offender. Equally problematic is the issue of who is responsible for investigating pornography on the internet when there is no clue as to where the images originate. Third, the internet by its nature is difficult to regulate, but many jurisdictions are reluctant to introduce laws that might help control internet use. There is also legal ambiguity as to whether ISPs should be liable for the material they carry. Difference in legislations across jurisdictions also create a problem. For example, in the United States, a child is defined as someone under 18, whereas in Australia, the age is something else. Moreover, countries vary in their commitment to enforce laws and act against offenders, either for cultural reasons or because of corruption. Those involved in cyber pornography possess high levels of technological expertise. Only the inexperienced low-level offenders are caught, if at all, while the veteran offenders easily escape. In addition to P2P networks, recent developments include remailers, servers that strip the sender's identity from email, and file encryption, a method of hiding or scrambling data. A technological race has developed between internet pornographers and law enforcement agencies. Lastly, the sheer amount of traffic in pornography makes the task of tracking down every person who visits a pornography site impossible. What is the legal framework in this regard? So far as India is concerned, we may refer to few sets of laws to regulate the subject. One, the traditional criminal law, and the more recently enacted Information Technology Act 2000, as well as the Protection of Children from Sexual Offences Act 2012. References may be made to sections 292 to 294 of the Indian Penal Code, which deals with law on obscenity. It may be mentioned that in most cases, the word pornography is used interchangeably with obscenity. However, it has been held in P.K. Somnath case that there is a difference between obscenity and pornography. The latter denotes writings, pictures, etc. intended to arouse sexual desires, while obscenity includes writings, etc. not intended to do so, but which have the tendency. Both offend public decency and morals. Pornography is obscenity in a more aggravated form. Section 292 IPC categorizes obscenity for the purposes of the section under the following three heads: lasciviousness, appealing to the prurient interest, and tending to deprave and corrupt persons who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. Depiction of a woman such as to excite impure thoughts in the minds of ordinary persons, of normal temperament have been taken to be included within the meaning. In line with the decisions elucidating obscenity, the question is each case is whether the tendency of the matter in question is to raise lewd, lustful or salacious interest in sexual matters. In other words, if the depiction is calculated to produce pernicious effect in depraving and debauching the minds of the persons into whose hands it might come, the matter may be designated as obscene. Referring to the Hicklin's test, the Supreme Court in Director General of Doordarshan versus Anand Patwardhan 2006 held that the basic test for obscenity would be whether the average person applying contemporary community standards would find it appealing to the prurient interest, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, whether the work taken as a whole lacks serious literary, artistic, political or scientific value. In Ajay Goswami case, however, 2007, the Supreme Court rejected the Hicklin's test as being incorrect and inappropriate in present times and evolved the community standard test in that obscenity has to be understood from the point of view of an average person by applying contemporary community standards. In 2000, the Information Technology Act was enacted that specifically addresses the question of obscenity on the net. Internet censorship in India has been quite stringent with manifold attempts to filter the content. These have taken the government of India by asking internet service providers, that is ISPs, to block access to social networking sites like Orkut due to concerns about the content posted on these sites. Section 67 of the Act prescribes whoever publishes or transmits in the electronic form any material which is lascivious or appeals to the prurient interest, or if the effect is such as to tend to deprave and corrupt persons who are likely having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it shall be punished. The act of transmission is sufficient to constitute an offence under section 67 of the Information Technology Act. Therefore, if any obscene material is published or transmitted in any electronic form, it is an offence under this section. The provisions of section 67 of the Information Technology Act are similar to section 292 of the IPC, where mere possession of the obscene material for one's own personal use may not be construed as an offence. However, it would be advisable to be cognizant of the fact that the prosecution can take a plea of abatement in a case of mere possession. The provisions of section 67 of the Information Technology Act are similar to section 292 of the Indian Penal Code, where mere possession of the obscene material for one's own personal use may not be construed as an offence. However, it would be advisable to be cognizant of the fact that the prosecution can take a plea of abatement in a case of mere possession. Section 67 of the Information Technology Act, read with section 21W, makes a person who receives, stores and transmits a pornographic message liable for the same. Along with this, the Internet Service Provider Guidelines in India in clause 1.12.4 of the terms and conditions make it mandatory for ISPs to ensure that objectionable, obscene, unauthorized or any other content are not transmitted through their network and to take necessary measures to prevent it. A strict liability regime was envisaged, providing inadequate safe harbors for the ISPs as they had the burden of proving lack of knowledge and exercise of due diligence to prevent the commission of such an offence. Subsequent to the Amendment Act of 2008, the definition of intermediary in section 21W has been expanded to include all sorts of computer services. Such a comprehensive definition ensures that a wide range of intermediaries is protected under safe harbor provisions, which was not the case in the Act of 2000. The Indian law so far does not make any sort of distinction between the intermediaries involved and applies the same standard to every type of intermediary irrespective of the level of knowledge. A positive trend has been seen with regard to immunity granted to intermediaries. Section 79 has been modified so as to bring it in conformity with the European Directive on Electronic Commerce 2000. The directive grants immunity to ISPs when they act as mere conduits and do not initiate the transmission, select the receiver, or select or modify the information contained in the transmission. This is a welcome measure as it involves a shift with fault liability regime where the intermediary is held liable only if he had knowledge of the transmission. The stand on pornography continues to be that of dealing with intermediaries with an iron hand. Thereafter, Section 67A of the IT Act lays down that whoever publishes or transmits or causes to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished. This new section clearly comes out with the explanation that an act which depicts sex appealing activities in electronic form is also punishable. The section thus enlarges the area of obscenity and includes within it depiction of sex activities. A more relevant section is section 67B of the Information Technology Act, which differentiates between mainstream pornography and child pornography and makes the latter an offence. Section 67B of the Information Technology Act states that anyone who publishes or transmits or causes to be published or transmitted material in any electronic form which depicts children engaged in sexually explicit act or conduct is punishable. The section is an exhaustive one and dwells on the subject of child pornography. It elaborately describes as to what constitutes child pornography and is a pioneer law in the country on the subject. The section makes it an offence not only the publication or transmission of it, but also the creation of, the browsing and downloading of these objectionable materials, though posted by others, as an offence. Thus, any human act connected with child pornography comes within the ambit of the section. It provides grave corporal punishment up to 5 years in first conviction and after 7 years in second conviction, and also imposes on him a pecuniary punishment. Apart from these sections, section 66E also relates to obscenity, which is the result of violation of privacy. The section talks of physical privacy and makes the protection of any physical part of a person without his or her consent an offence. The projection has been made an offence. The section, however, includes the phrase without his or her consent, which denotes that if such depiction of his or her physique is done with consent, then it will not be an offence. While section 292 IPC is a cognizable and bailable one, the sections under the IT Act are generally cognizable and non-bailable and triable by the magistrate of the first class. The POCSO Act 2012 is a comprehensive law to provide for the protection of children from offences of sexual assault, sexual harassment and pornography, while safeguarding the interests of the child at every stage of the judicial process by incorporating child-friendly mechanisms for reporting, recording of evidence, investigation and speedy trial of offences through designated courts. Section 13 of the Protection of Children from Sexual Offences Act provides that whoever uses a child in any form of media, electronic or otherwise, for the purposes of sexual gratification shall be punishable. Such offence is made out whether or not such use was intended for personal use or distribution. The section clarifies that sexual gratification will include a. representation of the sexual organs of a child, b. usage of a child engaged in real or simulated sexual acts with or without penetration, and c. the indecent or obscene representation of a child. The expression use a child means involving a child through any medium like print, electronic, computer or any other technology for preparation, production, offering, transmitting, publishing, facilitation and distribution of the pornographic material. The punishment for the offence is imprisonment for 5 years and fine, and on second or subsequent conviction, imprisonment which may extend to 7 years under section 14 of the Act 2012. Certain aggravated forms of the offence have also been elaborated in the statute in view of the fact that in most cases child pornography is accompanied by sexual abuse and exploitation of the child by the perpetrator. Thus, where an accused using a child for pornographic purpose also commits an offence of penetrative sexual assault, the punishment is enhanced to 10 years or life imprisonment, or where an accused using a child for pornographic purpose also commits an offence of aggravated penetrative sexual assault, the punishment is enhanced to rigorous imprisonment for life. Thus, to conclude, cyberspace has grown rapidly over the decade, and due to its borderless nature, widespread coverage and ease of use, it has become increasingly difficult to regulate the internet. Pornography has proved to be a vicious problem in cyberspace, and the consumption, dependency and addiction to it are proving major challenges. Child pornography has grown by leaps and bounds, and the industry has spread itself to affect tens and thousands of young children the world over. The Indian laws have witnessed several changes over the years with the introduction and amendment of the Information Technology Act and the latest Protection of Children from Sexual Offences Act, and it is expected that the problem of pornography will be controlled in the coming days. Thank you.